Hi everyone, thanks a lot for watching our YouTube channel. My name's Alan Lenczycki, your dry erase attorney, and welcome to lawjtlg.com. Anyhow, I wanted to talk today about a couple of things. People have asked us questions about my family law series of videos, and I want to follow up on our Divorce 101 video to talk about divorce process and actually the allocation of parental responsibilities more in depth. So in that video, we talked a little bit about the 3 documents that you need to get a divorce done. And one of them is the allocation judgment. And remember, I'm in Lake County, Illinois attorney, and this is April of 2022. So that's what the state of the law is and where I am. Everything is different in every jurisdiction. So if you're in a different state, you need to bone up on your own state's rules. But in Illinois, let's talk about the first document, the most important document probably, the allocation judgment. So we also call this a parenting plan. And the reason is that it helps 2 parties who are getting divorced in a D case, a divorce case, that's when people are married and then they want to split up this marriage, or parties in an F case, a family case. A family case is when 2 parties have children or a child, but never were married. And that's just like, people call it baby mama drama, whatever this is, but it's really serious. And an F case is different from a divorce case, but they both need this. They need this parenting plan, okay? And to put together a parenting plan, there are 3 ways that a party or the parties can do that, okay? The first one is by agreement. This is, in my opinion, and in the opinion of any good lawyer, this is the best way, okay? That means that you and your spouse maybe go to Starbucks or talk over the breakfast table, not over a bottle of wine, because this could make an unfortunate disagreement occur. But my recommendation would be that you and your spouse, you talk, honey, we're getting divorced. What are we going to do with the kids? Where are we going to live? Where are they going to live? Who's going to have them when? And who's going to call the shots about the kids? Maybe that mom, in a lot of families, is setting up doctor's appointments. So should she continue to make medical decisions for the kids? Or are we going to do this jointly? There's a strong presumption for joint decision making in Lake County courts, at least, unless the person that they're thinking about not giving decision making has some sort of legal disability, a problem. I drink too much. I have mental health problems. I have had bad decision making in the past. Those are some reasons that a court may not give somebody a decision making power over the children in a divorce case or a family law case when we have one of these things. But anyway, I digress. The first thing to figure out is, do you guys agree? Do the parties getting divorced agree? Because if they do, we can write whatever we want in the allocation judgment, in the parenting plan. We write that in there because that's what the parties have agreed to within reason, okay? If you can't agree, and this happens, that's why I am employed. If you can't agree, well then how can the parties still come to an agreement at the end of the day? Or how can they have a livable and workable deal or order at the end of the day? Well, the second step would be mediation. Mediation is a process that's really cool. I really support that. When people can't talk, you know what? At least they can sometimes go to a mediator. Those are lawyers that are on a mediator list that we've got in Lake County, and the 2 attorneys, now with their own private lawyer. So if husband is working with me and wife is working with another lawyer, I and the other lawyer, the opposing counsel, don't go to the mediation session, but the parties themselves will. In the old days, they used to go to somebody's office. We don't do that anymore usually. Now it's done by Zoom. But I guess hopefully that office visit mediation will resume because it's really effective when people are in person and mediation's occurring. But mediation will happen by Zoom, okay? The parties hopefully have a list. They've prepped with their lawyers. You know, here's the things I have to have, things I'd like to have, things I can give away as a charity to the other side. And then they bargain, and hopefully they can hash out all their deals, all their issues. But mediation is still helpful even if the parties can't finish every one of their issues. Let's say there's 10 issues that the people have between them. Schedule, decision-making, whatever it is. If we can knock down 7 of those bowling pins, well then that's 3 fewer things for the judge to have to figure out down the line, okay? So mediation is an important tool. Call me if you want to have more questions about that. Anyway, the third thing that can happen if the parties can't agree, mediation fails, is a guardian ad litem could be appointed, okay? A guardian ad litem is another lawyer. It's another expense for a divorcing couple or for a couple that's in a family law case. So it's an expense that usually is split 50-50. Sometimes if the one party is a lot richer than the other one, has a higher income earning ability, then it won't be split 50-50, maybe 60-40, sometimes 90-10 in a situation where one party has tons more financial assets than the other party. I don't know, I guess it could be 100% and 0%. It depends on the discretion of the judge and what the judge thinks is fair, what the judge thinks is equitable, okay? Anyway, but a guardian ad litem is a lawyer that's appointed by the judge to act on behalf of the children. So it's the kid's lawyer. That guardian ad litem will do an investigation, and the investigation can be of various levels of complexity based on what the guardian ad litem thinks that the family needs, and based on the GAL, him or herself, because they're just lawyers like us, and some are more industrious, some like less industrious, some wanted to have a very thorough investigation, some people, they feel like it is not needed in every case. So you really get a wide variety of GALs, just like there's a wide variety of lawyers. And a great GAL can really help figure out the case really fast. An okay GAL or one that's not so good can be an obstacle in a case that needs to be overcome, and we can talk about that another time. But anyway, you've got to pay for the GAL, and then you want to cooperate with the GAL. One thing that I tell my clients is the GAL is kind of like Batman coming in your case, and Batman can help you. You know, Batman's great, Batman's a hero. And sometimes the GAL, if you're conveying, you know, that you're doing a good job as a parent, and here's what you want, and you think it's reasonable, and you don't have these legal disabilities or problems that would cause the GAL to not go on team dad or team mom, I don't know. You've got to make sure to try to enlist the GAL, to try to bring that GAL onto your side so that they agree with you in the best interest of the kids, and cooperate 100%, tell the truth. Anyway, if you can't do that, the GAL is giving an opinion that doesn't work for you, or for some reason doesn't work out, you have to have a trial. And then the judge will listen to the testimony and the opinion of the guardian ad litem. That's the last way that these parenting decisions can be set, is a trial. The pen's kind of dying here, but anyway, a trial is the least desirable option. It's the highest conflict and the highest expense. And one of the witnesses will be the GAL. So if during the case, one of the parties didn't like what the GAL said, well, guess what? You're still maybe doing what the GAL said anyhow, because the GAL is going to be very influential. His or her opinion to the court in a trial. I mean, what's the judge going to do? Ignore it? They sometimes can not agree with everything that the GAL has to say, but it's really strong testimony. Anyway, that's a lot of the considerations going into the formation of an allocation judgment. But what's in the document itself, once these things have been ordered, either by the judge or by agreement of the parties or whatever? Well, we're looking to see about decision-making over the children. We're looking to see about parenting time. We're looking to see about provisions that have to do with the parties interacting with each other, and stuff that maybe you don't think about, like who's going to get Easter, who's going to get the first half of spring break. All these things are set out in the allocation judgment. Call me or call another attorney if you want to talk about those things. I'm Alan Lenczycki, Law JTLG. Like and subscribe.